Good morning, all. I'm Srishna K. First MSc Biology, St. Mary's College, Thrissur. Today we are dealing with the topic environmental priorities, strategies, and environmental legislation in India. The Environment Act 1986 came into force on 19th November 1986. This act extends to the whole of India. This act provides for the protection and improvement of environment and for matters connected therewith. Section 2 of the Act defines certain terms connected with the environment. Some of the terms defined by the Act are the first one is environment. Environment includes water, air, land, and the interrelationship which exists among water, air, land, and human beings, other living creatures, plants, microorganisms, and property. The second term, environmental pollutant, means any solid, liquid, or gaseous substances present in such concentration as may be or tend to be injurious to environment. Environmental pollution. It means the presence of any solid, liquid, or gaseous substances present in such concentration as may be or tend to be injurious to the environment. There are some powers for the central government in maintaining the environmental protection. Section 3 of the Act has empowered the central government to take all such measures as it seems necessary for the purpose of protecting and improving the quality of environment and preventing, controlling and abating environmental pollution. In particular, it can take measures with respect to the following matters: coordination of actions by the state governments, officers and other authorities, planning and execution of a nationwide program for the prevention, control and abatement of environmental pollution, laying down standards for the quality of environment in its various aspects, laying down standards for discharge of environmental pollutants from various sources whatsoever, restriction of areas in which any industries, operations or processes or class of industries, operations or processes shall not be carried out or shall be carried out subject to certain safeguards, laying down procedures and safeguards for the prevention of accidents which may cause environmental pollution and remedial measures of such accidents, laying down procedures and safeguards for the handling of hazardous substances, examination of such manufacturing process materials and substances as are likely to cause environmental pollution, carrying out and sponsoring investigations and research relating to problems of environmental pollution, collection and dissemination of information on environmental pollution. The first one we are dealing with is Air Act. The Air Prevention and Control of Pollution Act 1981 came into force on 29 March 1981. This act extends to the whole of India. The important features of this act are: this act empowers the central and state pollution control boards to declare pollution control areas, restrictions on certain industrial units, authority of the boards to limit evasion of air pollutants, power of entry, inspection, testing samples, and analyzing offences by companies and government, etc. This act specially empowers state government to designate air pollution areas and to prescribe the types of fuel to be used in the designed areas. Under this act, no person can operate certain types of industries without the consent of the state board. This act empowers the central board to advise the central government on matters of air pollution, coordinate the activities of state boards, lay down desirable air quality standards, and train human resources to monitor pollutions. The state boards are empowered to establish laboratories and appoint government analysis for analyzing samples of air or commissions for purpose of implementing the act. The state government are empowered by this act to declare any area within the state an air pollution control area after consulting the state board. The government can prohibit the use of certain fuels materials, or appliances which may cause air pollution. The second one is Water Act. The Water Prevention and Control of Pollution Act 1974 came into force on 23rd March 1974. It was amended in 1988. This act applies to the whole of India. The important features of this act are: this act provides for establishment of central and state boards for the prevention and control of water pollution. What under this act, the central and state boards are given power to prevent water pollution, take water samples and their analysis, discharge of sewage, trade effluents, etc. The 1988 amendment to this act requires that there should be no discharge of trade effluent or sewage without the permission of the state board. If any industry contravenes this provision, it can be closed immediately. The state board can demand any information from any person in order to ensure compliance with the provision of this act. Next, Wildlife Protection Act. The Wildlife Protection Act 1972 was amended in 1983, 1986, 1991 and 2003. Provides for the protection of wild animals, birds and plants to ensure ecological and environmental security of the country. This act seeks to constitute a wildlife advisory board for each state, regulate hunting of wild animals and birds, lay down the procedures for declaring areas as sanctuaries, national parks, etc., regulate possession, acquisition, or transfer or trade in wild animals, animal articles, etc., provide penalties for the contravention of this act, provide for captive breeding program for endangered species. Forest Conservation Act. The Forest Conservation Act 1988, as amended in 1988, is concerned with the conservation of forests. The main features of this act are: this act covers all types of forests, including reserve forest, protected forest, or any forested land irrespective of its ownership. This act was amended in 1988, provides that the leasing of forest land to persons or any authority, corporation, agency, or any other organization not owned, managed, or controlled by government, and clearing of trees which have grown naturally in any forest land will require prior approval of the central government. This act contains punitive provisions for the enforcement machinery. The 1992 amendment to the Forest Act allows some non-forest activities in forests without cutting trees or limited cutting with prior approval of central government. Those activities are setting of transmission lines, seismic survey, exploration, drilling, and hydroelectric projects. Wildlife sanctuaries, national parks, etc. are totally prohibited for any exploration or survey under this act without the prior approval of the central government, even if no tree felling is involved. Cultivation of the coffee, spices, rubber, and plants which are cash crops are included in non-forestry activities not allowed in reserve forest. Even cultivation of fruit-bearing trees of yielding plants or plants of medicinal value in forest areas has to be first approved by the central government. Mining is a non-forestry activity, and so for mining in a forest area, prior approval of the central government is mandatory. Issues involved in enforcement of environmental legislation. In India, there are constitutional provisions for the protection of environment laid down in Article 48A, Article 51A. Besides the constitutional provisions for the protection of environment, there are also about 200 central and state legislation to protect our environment. However, there is a wide gap between what is provided in the legislation and what is actually practiced in regard to environmental protection. This is due to the fact that there are some issues or problems in the enforcement of environmental legislations. Some of the important issues in the enforcement of environmental legislation are: the main objective of forestry in India has been its commercial exploitation at the control of long-term ecological security. The various provisions in our legislation regarding forestry have not been properly observed. The result is decline in forest cover in the country. Despite the existence of Wildlife Act, poaching of wild animals goes on. Several species of wildlife have become extinct because of poaching. Poaching is not effectively checked because there are no stringent provisions in the Wildlife Act to punish the poachers, and the majority of the people of India are not punished for large scale poaching of wild animals. In the Environment Protection Act, all powers in respect of environmental protection are vested in the hands of the central government, and the state governments do not have sufficient powers to enforce the provisions of the Act. This excessive centralization of powers in an important hurdle for the efficient enforcement of the provisions of the Act. There is a clause in the Environmental Protection Act which provides that if an offence is punishable under this Act and also under any other Act, the offenders should be punished under the other acts and not under this Act. The penal provisions of the other Act are less stringent than the penal provisions of this Act. This has reduced the effectiveness of penal provisions and allowed the offenders to get away with the minor punishment. There are enough legislations in India for the protection of environment, but the authorities responsible for the enforcement of the various environmental decisions are different. This is also an issue involved in the effective enforcement of environmental legislation. Ineffective enforcement of the safety provisions of some of the environmental legislation, such as the Factories Act, the various pollution control acts, etc., is a major issue or problem connected with the enforcement of environmental legislation. The society's response to crime of pollution is not quite serious. Unfavorable response of the society to crime of pollution is also one of the tasks in the enforcement of environmental legislation. Lack of knowledge of pollution control laws on the part of stakeholders, the business community, and the individuals, and the indifference of intellectual to the environmental degradation also one of the issue connected with the effective implementation of environmental legislation. Thank you.